Уважаемые участники конкурса, члены жюри, приглашенные, сегодня мы в Торгово-промышленной палате Российской Федерации проводим финальную часть, заключительную часть конкурса по международному арбитражу, коммерческому арбитражу, посвященному Михаилу Григорьевичу Розенбергу. Это выдающий ученый, юрист, человек, который очень много сделал для развития и становления международного, да и вообще арбитража в Российской Федерации. Он много сделал и для развития наших связей, международных связей. Конкурс проходит на основе дел, которые рассматривались и рассматриваются в нашем Международном коммерческом арбитражном суде. Мы его проводим вместе с Всероссийской академией внешней торговли. В этом году это традиционный конкурс, но в этом году он проходит в необычной форме, в режиме онлайн. Это, с одной стороны, нововведение, с другой стороны, оно основано на той практике, которая складываться стала в последние месяцы у нас в Международном коммерческом арбитражном суде. Сегодня многие дела рассматриваются дистанционно, и участники рассмотрения, и арбитры находятся не только иногда в разных регионах Российской Федерации, но и в разных точках нашей планеты. Тем не менее, дела такие рассматриваются. И мне кажется, что многим участникам конкурса удалось поработать в таком же режиме на основе тех дел, которые им представили. В этом конкурсе сегодня участвуют десятки команд из России, Белоруссии, Казахстана. Они показывают весьма и весьма достойные результаты. И я думаю, что сегодня будут определены самые достойные. Тем, кто станет победителем, появится возможность практиковаться в нашем Международном коммерческом арбитражном суде при Торгово-промышленной палате. Я полагаю, что будет возможность по окончании учебы направиться на работу или в различные регионы Российской Федерации, где сегодня действуют уже филиалы нашего МКАСа в 20 регионах Российской Федерации, или в наш КАС при Федеральной торгово-промышленной палате, в систему торгово-промышленных палат. Мы будем рады видеть всех тех, кто получил достойные знания, но и поучаствовал в этом конкурсе. Я хочу пожелать всем участникам больших успехов, потому что МКАС сегодня один из самых авторитетных арбитражных органов в мире. Это не просто слова, это подтверждено цифрами и фактами. Сегодня МКАС в прошедшем году, например, рассмотрел более 500 дел. Половина из них практически это дела международного характера. К нам обратились представители 60 стран для того, чтобы разобраться в спорах. У нас большой пул юристов, международный пул, потому что в него входит более 300 юристов, представляющие 25 стран мира. Поэтому вы имеете возможность влиться в очень серьезный коллектив, юридический международный коллектив. И я хочу пожелать вам успехов во всех начинаниях, но, естественно, участия в этом конкурсе.
Okay, good morning, colleagues. Let me present myself first. I am president of the International Commercial Arbitration Court at the Russian Chamber of Commerce, as well as of the Maritime Arbitration Commission at the same chamber. I was appointed to be chairman in this tribunal, which is the version in the English language, and we have here two parties, claimant and respondent, and in fact, in this case, there are two claimants, since we have a counterclaim as well from the Belarusian State University. And let me give the floor to my colleagues. To the left of myself is a distinguished international arbitrator, Jonathan Hines. And we agreed that each arbitrator speaks several words about himself. Please, Jonathan.
Yes, I'm very pleased to be here on this panel of arbitrators. I am from the United States. I have been living here for 20 years and working here. I've been an MCAS arbitrator for many years and sit on the Presidium under Professor Kostin's guidance. I also, I think I'm free to say, since both of our teams are from Belarus, so I'm not showing favoritism, that I have a special place in my heart for Belarus. The first time I was here studying at MGU in 1979 on the Юридический факультет, I was sent to BGU for 2 months to do part of my stažировка there, and I have very fond memories.
Thank you, Jonathan. To the right of myself is Timur Aitkulov. He is a partner in the very important international law firm, but let him speak for himself.
Yes, hello. I'm very honored to be part of this arbitral tribunal. So I expect this hearing will be very interesting. As Professor Kostin said, I'm a partner at Clifford Chance. I'm head of dispute resolution in the Moscow office. I'm also a member of the ICC Court of Arbitration from Russia.
Okay, thank you. Very moderate presentations, I would say. But well, to save the time, I'll stop here, and let us agree upon timing. I was said that we have the time till 11:40. So this is 1 hour and a half. Well, will try to cope within this time frame. It is supposed that, according to the MCAS, so this is ICAC at the Russian Chamber of Commerce, tradition, we start from the claimant presenting his case. Well, note that there might be questions even at this time. Well, some clarifications might be needed by the arbitrators. Then we refer and we expect that when presenting the team, it would be said how the questions are split between the two representatives. So we know this beforehand. Then we have the same, we allocate the same time to the respondent and his counterclaimant as well. Questions also might be asked by the arbitrators. Then we, after this, we might give some time for questions and answers between the parties. Then it comes, this is the next stage, it comes to the fundamental questions on behalf of the tribunal. And then some final closing remarks would be the last stage. But let us be flexible, as arbitration is a flexible mechanism, so we might adapt if need be. As a rule, I would ask before we start the proceedings, if there are any preliminary remarks might be of a procedural nature. My question goes to the claimant. Are there any questions? Perhaps there might be some doubts about the composition of the tribunal.
No, Mr. Chairman, at this time we have no objections.
Thank you. Respondent, please.
Thank you, Mr. Chairman. We have no objections. Thank you.
Okay, so, well, claimants, you have the floor. Around 20 minutes, please do your job.
Thank you. Good morning, Mr. Chairman, honorable members of this arbitral tribunal. My name is Ivan Yurevich, and I will assume the jurisdictional and procedural issues on behalf of the claimant in this proceeding. And in this regard, claimant will have three main submissions. Firstly, the arbitral tribunal has the necessary jurisdiction to hear the dispute arising from the contract. Secondly, the arbitral tribunal has no jurisdiction over the dispute from the distribution agreement. And thirdly, alternatively, if the arbitral tribunal considers otherwise, the counterclaim of respondent still cannot be admitted as a counterclaim in these proceedings. Starting with our first submission, we state that this arbitral tribunal has the necessary jurisdiction to hear the dispute arising from the contract, based on three main reasons. Firstly, the dispute is arbitrable under the arbitration law of the Russian Federation, which is the lex arbiter in these proceedings. Secondly, the arbitration clause contained in the contract is perfectly valid and enforceable. And thirdly, the agreed dispute resolution procedure between the parties was complied by the claimant. And since there are no objections to the jurisdiction of this tribunal regarding the dispute arising from the contract, we would like to suggest to move directly to our second submission, that this arbitral tribunal has no jurisdiction to hear the dispute arising from the distribution agreement. And the basic reason for that is that the arbitration clause contained in the distribution agreement is defective and therefore unenforceable. And in this regard, I would like to invite this tribunal to open page 25 of the record. Article 9 of the distribution agreement contained the arbitration agreement concluded between the parties. However, the English version of this arbitration agreement reads arbitration in Moscow as an arbitral institution to which the dispute is to be submitted. Such reference to the arbitral institution is way too vague in order to determine the exact intent of the parties to submit the dispute to this exact arbitral tribunal. The view that the absence of a clear reference to the arbitral institution constitutes a reason for the unenforceability of the arbitration clause was held, for example, by Professor Gary Bourne in his book on international commercial arbitration, where he states that in such cases, it is impossible to determine the real intent of the parties. And we consider that in this regard, this arbitration clause is unenforceable. However, anticipating the arguments of the opposing party regarding the Russian version of the same arbitration agreement, we submit that the English version of the agreement shall prevail in this regard. And for such an interpretation, we use the provisions of Chapter 4 of UNIDROIT principles. Article 4.7 states that in case of a language discrepancy between two versions of a contract provision, the priority shall be given to the version drafted initially. However, in the record, we have no evidence regarding which version was drafted initially, and therefore we shall apply the more general rule. This rule is contained in Article 4.1 of the UNIDROIT principles, and it states that while interpreting a contract provision, a special regard shall be given to the circumstances related to the conclusion of this provision. And the official commentary to the UNIDROIT principles, inter alia, in this, as an example for such circumstances, names the linguistic skills of the parties. As it is clear from the record, all the correspondence between the parties was being conducted in English. Moreover, while our client is from Russia, the opposing party is an Italian party, and therefore, applying the reasonable person test, we assume that the common language of the communication between the parties and the language commonly understood by them was the English version, and therefore the English version of the arbitration agreement is prevailing. However, even if the arbitral tribunal disregards this argument and decides to apply the Russian version of the arbitration agreement, which differs from the English version, such a version is still unenforceable as the name of the arbitral institution is invalid. Namely, the Russian version of the arbitration clause in literal translation refers to the arbitration court at the Chamber of Commerce and Industry of the Russian Federation. However, the correct name of the arbitral institution is International Commercial Arbitration Court. And therefore, the parties failed to agree to the considerment of this dispute as an existing arbitral institution. And the view that a mistake in the name of the arbitral institution constitutes a reason for the unenforceability of the whole clause is commonly adopted all over the world, for example, in the United States, at the Russian Federation, in Belarus, and in Spain, just to name a few examples. And an example case would be the case of the Supreme Court of the Russian Federation, decided in 2018 in the case Dredging and Maritime versus Inchtranstroy, where the Supreme Court of the Russian Federation held that the absence of one word in the name of the arbitral institution already constitutes a reason for a court to invalidate the whole arbitral award on the reason of the lack of jurisdiction of the tribunal. To the same conclusion came Professor Alexander Beloklavek in his article analyzing the common mistakes in drafting of the arbitration clause. And therefore, claimant respectfully submits that both English and Russian version of the arbitration clause contained in the distribution agreement are defective and therefore unenforceable. And from that follows the conclusion that this arbitral tribunal cannot determine its jurisdiction from a defective and unenforceable clause. However, alternatively, if the arbitral tribunal finds itself having the necessary jurisdiction.
Excuse me, Mr. Yurievich, I'd like to ask a question, if I may. You've made a series of admirable technical arguments with impressive citations, but can't we as the tribunal take into account some other considerations that the other contract, the main contract, shall we say, under discussion here, under debate, the sale contract clearly provides for MCAS jurisdiction. And this other contract was between the same parties, concluded not very far apart in time. And one of the languages, albeit imperfectly, does seem to refer to our tribunal, our institution. So why can't we take that into consideration as a reasonable matter under Uniddraw and other principles which are applicable here, and conclude that the parties intended for both contracts to be heard before MCAS? And even if that is not so, a second question, don't we have the power, do we have the power to consolidate the two cases, even if you object?
I do understand your concerns, Mr. Chairman. However, answering to the first part of your question, we acknowledge that the arbitration clause contained in the main contract is valid and enforceable. However, the arbitral tribunal cannot determine its jurisdiction over the dispute from the distribution agreement from that clause, because the scope of the clause contained in the contract is specifically limited to the disputes arising from the contract, and therefore the dispute from the distribution agreement cannot fall within the scope of the arbitration clause contained in the contract. Addressing the second part of your question regarding the consolidation of the proceedings, the ICAC rules provides that in order for two proceedings to be consolidated, it is necessary to have an arbitration clause or arbitration clauses covering two disputes. And the mere fact that one of the disputes is covered by the arbitration clause does not give a reason for the arbitral tribunal to include the second dispute over the same arbitration clause. And therefore, this dispute cannot be heard by this tribunal.
Okay, I have another question to you in this respect, if I may. If I understood it correctly, you said that when interpreting the arbitration clause, we need to take into account which version was prepared first. And then you say that the English version was prepared first. Could you please refer us to the evidence in the file which supports your statement?
Let me clarify myself, Mr. Arbitrator. We do not submit that the English version was drafted first. We state that there is no evidence of which version was drafted first in the record, and therefore we shall apply a more general rule, since we do not know which version was drafted initially.
Okay, your position about jurisdiction is more or less clear. We had two questions on behalf of tribunal, so you can proceed to the merits, if possible.
Thank you, Mr. Chairman.
Thank you. Good morning, honorable members of the Arbitral Tribunal. My name is Diana Shevtsova, and I'm the counsel appearing on behalf of the claimant, or Stan Kamash, in this dispute against SRL Italia-Tornio. And in the next 17 minutes, I will guide the Arbitral Tribunal through the merits of the case regarding the distribution agreement and the contract. Firstly, I would like to start with the submissions regarding the distribution agreement. And in this regard, we have one main submission. The distribution agreement does not prohibit the claimant to open companies on the territory of Italy, and SRL Penzastan complies with the distribution agreement. Respondent is granted on the territory of, on the contract territory, the exclusive right to advertise, distribute, and sell the products of the exporter. However, the wording of this provision does not exclude the claimant's right to open its subsidiary with any other purpose except for those mentioned in the distribution agreement. Moreover, we would like to draw your attention to the fact that in 2015-2016, OO Stan Kamash received licenses for distribution in the European Union, not only of CNC lathes series ST16A25, but also of the universal lathes series ST16K20. And the distribution agreement, only CNC lathes were mentioned and universal lathes were not mentioned. And for this reason, SRL Penzastang could be opened on the territory of Italy and it would not be the violation of the distribution agreement. In this regard, we rely on the MDF door case, where the claim had no impact on the existence of the respondent's obligation to pay the price which arises from the contract on sale of goods. And the operation of SRL Penzastan in no way impacts the obligations under another document which were concluded between the parties. Now, moving on to the merits regarding the contract. Within this claim, the claimant has two main submissions. Firstly, that claimant is entitled to the payment for the goods delivered to the respondent. And secondly, that the claimant is entitled to a penalty for the delay in payment. Within our first submission, we have two main arguments. Firstly, that the respondent has a contractual obligation to pay for the goods. And secondly, that the lacking features detected by the respondent do not constitute a fundamental breach of the contract. Under Article 1 of the contract, respondent is obliged to pay for the goods. Under Article 59 of the CISG, the buyer must pay the price for the goods on the date which is fixed in the contract or which is determinable from its text. A party who has performed the contract either in wholly or in part may claim the restitution from the other party of whatever the first party supplied or paid for under the contract. By the 30th of October 2017, the claimant has fulfilled its obligations and delivered the goods to the respondent. By this date, the respondent was obliged to pay 90% of the sum for the latest. The amount of the sum is 388,800 euro, and you may see the calculations in the paragraphs 91 and 94 of our memorandum. However, the respondent failed to make such payment even after two notifications which were sent by the claimant. Now, turning to our second argument regarding the lacking features. Within this claim, the applicant has two main arguments. Firstly, that absence of fibre rapport and documentation does not hinder the goods from serving their purpose. And secondly, the presence of safety locks was not arranged by the parties. Firstly, the goods should fit for the purposes for which they were produced. A breach of the contract committed by one of the parties is fundamental if it results in such a detriment to the other party as substantially deprive him of what he is entitled to expect under the contract. However, as you can see from the point 6 of the response to the statement of claim, the respondent accepted the latest. And absence of fibre rapport and documentation does not itself make the whole machine tool not fit for their purpose. Secondly, the seller is obliged to deliver to the buyer the goods that correspond to the quantity provisions of the contract for the sale of the goods. As you may see from the annex to the contract, the two versions of the language versions are different, and the complete set of the goods which are included in the annex are also different. And as was mentioned by my co-counsel, in this regard, we should the English version of the contract should prevail, as it puts both parties in the equal position in this regard. Acting in good faith, which means without trickery, the claimant observed the English version of the contract, which does not mention the safety locks. However, the English version mentions the circuit breakers, which were not mentioned in the Russian version of the contract, but the circuit breakers were delivered to the respondent. Therefore, the respondent cannot rely on the fundamental breach of the contract as a ground for non-payment for the goods. Now, turning to our second submission regarding the delay in payment. Within this submission, the claimant has two main arguments. Firstly, that respondent is obliged to pay a penalty for the delay in payment, and secondly, that respondent cannot refer to an impediment in order to exempt itself from paying for the goods. Regarding our first argument, following the principle of freedom of contract, parties may include to the contract a clause which stipulates a penalty for the delay in payment as the method of ensuring the fulfillment of the obligations of the parties. And under Article 78 of the CISG, if party fails to pay the price or any other sum which is expected from it under the contract, the other party is entitled to the interest. And Article 2 of the contract provides a penalty for the delay in payment. For the calculation of the penalty, you may see the paragraph 136 of our memorial. The claimant fulfilled its obligations duly by delivering the goods. However, the respondent failed to pay for the goods in time. Therefore, the respondent is obliged to pay a penalty under the contract. Turning to our second argument regarding the impediment. Respondent referred to inability.
May I ask a question? And that is, what is your position as to the main complaints of the respondent as with regard to the goods that were delivered, the defects, the deficiencies? We know what respondent says the effect of that is and what should happen. What do you say should happen? Did you remedy any of the problems that the respondent notified you of? Should you have the responsibility to? What should be the consequence, if any, in your view, of the deficiencies pointed up by the respondent immediately after the delivery and in its response in this tribunal?
Mr. Arbitrator, the respondent would be completely right if our party made a fundamental breach of the contract. However, I want you now to compare the prices of the details which were not delivered and the prices of the machine tools itself. Vibe rapport and safety locks cost about a couple of dollars, and they can be easily bought in any country. However, the whole machine tools, the 5 latest which were delivered to the respondent, cost more than $400,000 and euro. I'm sorry, and the respondent did not pay the 90% of the sum of the latest. And on one side, we have a couple of dollar details, and on the other side, we have almost 400,000 euro. And a couple of dollar details are not a fundamental breach of the contract. They are not, these details are not the most important part of the machine tools. And underpaying 388,800 euro is a fundamental breach of the contract.
Okay, so your position basically is that at most, the respondent is entitled to a couple of dollars or a couple of euros credit, as you put it, against what they owe you. Because we, of course, as a tribunal, it's very nice to cite this and that legal provision, but we also have a responsibility to focus on the facts, the real life situation that's before us. So that is your position, yeah?
Yes, as the remedy, the respondent could, for example, reduce the price that they pay and just minus the details that were not delivered to the respondent. And this is not such a big sum, actually.
Okay, thank you. I'll ask one question, though I have many. You referred to Article 78 of the Vienna Convention, and when considering the contractual clause with regard to penalty or liquidated damages. So are these instruments equal? Interest under the convention and penalty under the contract? Please be short, and so we can go further and give the floor to your procedural opponents, please.
Mr. Arbitrator, may you please rephrase your question?
You referred to Article 78 of the Vienna Convention, which embraces interest. Is it correct?
Yes, that's correct.
And you linked it with the penalty clause in the contract.
Yes, to the Article 2 of the contract.
So it's your opinion, it's your position that these two things are the same?
No, these are not the same, but they are interrelated. The Article 78 of the CISG is a more general rule, and it says that the party who fails to pay the price, the other party who did not receive the price is entitled to the interest under the contract. And the contract stipulates that.
Okay, thank you. I observed that in the documents we have at hand, there's at least 2 times it's been referred to penalties, and at other times with regard to interest. Okay, thank you.
I have one question, Mr. President. So you said that actually some of the details of this machinery were not delivered to you, and you say that the price of these parts is minor. But I understand that one of the things which was not delivered is documentation with respect to this machinery. And my understanding is sometimes you cannot use the equipment if you do not have the documentation. So it may well be the case that the equipment is worthless without the documentation. So, and then I wonder where in the case file you have found evidence which supported your conclusion that the value of the documentation which was and other equipment which was not delivered is minor.
If I may interfere for a moment, Mr. Arbitrator, we submit that the absence of documentation under the contract on the sale of goods does not constitute a fundamental breach of the contract, because under the provisions of the distribution agreement, our client already provided respondents with all the documentation necessary for the operation of the CNC lasers before any CNC lasers were produced and delivered. And therefore, at the time of delivery, respondent already was in possession of all the necessary documentation. And the mere fact that the copies of this documentation were absent with the exact machinery does not constitute a reason for respondent not to pay the whole contractual price of the goods.
Okay, I understand. Thank you.
Okay, I believe that we spent about 30 minutes with the claimant, and my proposal is to give the floor to the respondents, which can elaborate not only about the counterclaim, but about their response to the original claim. Please go ahead.
Thank you, honorable members of the Arbitral Tribunal. Good morning, honorable members of the Arbitral Tribunal. My name is Matvey Nefin, and at the current hearings, I, with my co-counsel Veronika Emelianchuk, are representing the views of Italotornia SLR, a respected Italian company, at the case against OO Stankomash, which has failed to fulfill its contractual obligations and filed a claim containing unfounded demands. I will present procedural part of our position, and Veronica will present material part. I would like to reserve 15 minutes for each part of the position respectively. I will divide my position in two parts. Firstly, I will follow the claimant structure, and secondly, I will deepen on the issue of why the rules of the ICIC allows us to hear the counterclaim at the current proceedings. Moving to the first part of my position, firstly, as it was mentioned by the claimant, arbitration clause is defective. However, it is not. The mere interpretation of the claimant established allows us to say that claimant claims that English version shall prevail, as it is in his opinion, widely accepted language, and therefore a claimant acted in good faith. However, none of the arguments, nothing allows us to indicate that in the problem 2020 that the respondent was not aware and did not know Russian language. Indeed, the contract is drafted in two languages for a reason. However, this reason shall not exactly be due to the fact that one of the parties does not know Russian language. Moreover, a respondent proposes that the wording shall be interpreted in accordance with the intentions of the party, which are clear at the case at hand. As it was previously mentioned by the arbitrator, the correct name of the institution is mentioned in the main contract, and moreover, as it was mentioned by the claimant, the name of the institution in Russian version of the agreement also of the contract also contains some mistakes. However, it is clearly indicated. It is said that that it shall be the International Commercial Arbitration Institution. And I would like to ask, and there are no other institutions established which will fit the established criteria. Moving to the mentioned by the claimant in its memorandum and in its oral part, criteria established by the rules of the ICIC, those are the following. Namely, there is another arbitration agreement referring the disputes to the ICIC and comparable with the first arbitration agreement in its content, which covers such a claim or a set-off, and the counterclaim or the set-off are substantively related to the principal claims. Those are the criteria for the counterclaim to be considered established and heard at the proceedings. Respondent would like to mention that our counterclaim satisfies all of the established criteria in the above mentioned paragraph. The counterclaim satisfies the first criteria, as the arbitration agreement in the agreement is present and provides for the arbitration of ICIC in Russian column of the Article 9. Moreover, as it was previously mentioned, respondent insist on the fact that that the wording shall be interpreted in accordance with the intentions of the party. So the intentions was to choose single arbitral institution, despite of the absence of the name of the arbitral institution in English column. Moreover, balance of the parties was referred by the claimant in its memorandum, and in respondent's opinion, to satisfy such a balance, the wording shall be once again interpreted in accordance with the intentions of the parties. Furthermore, the second sub-criteria established by the rules is also satisfied. Namely, the arbitration agreement in the contract and in the agreement are close to each other by their content, as the scope of the disputes referred to the arbitration by the agreement includes the disputes referred to the same arbitral institution by the contract. To be more specific in the current regard, the agreement sets the arbitration procedure for citation all disputes, disagreements, or claims arising from or in connection with this agreement. and the contract refers to arbitration all disputes and differences which may arise between the parties in the course of the performance of the contract. At the same time, as it is indicated above, it is necessary to conclude and execute additional contracts for the agreement to be implemented, and such provision is contained in the agreement indeed. It means that to comply with the jurisdiction rule established in the agreement, it is necessary to transfer the disputes which may arise in the course of the performance of the additionally concluded contracts to the arbitration at hand. Moreover, respondent highlights that the same jurisdiction rule is established in the contract. Considering the scope of the disputes referred to the arbitration by the agreement, any reasonable person would consider that the arbitration agreement in the contract is compatible in its content with the arbitration agreement in the agreement.
Moreover, if I may, if despite your fine arguments, the claimant is not in agreement with you that the two cases should be two contract disputes, the two contracts should be consolidated before us, may we do it anyway? And do we have a higher threshold, a higher standard that we need to meet before we agree to take the distribution case in consolidation, even if the claimant, where the claimant objects?
Thank you. As far as I understood your question, it is whether the arbitral tribunal itself has the right to decide on its competence. Is it so?
Yes, but what's your view as to a possible different standard we need to apply or different threshold we need to meet if one side objects?
Well, of course. Honorable members of the arbitral tribunal, the principle that was previously referred to by the claimant, and this principle is indeed well established in international commercial arbitrations all over the world, the principle of competence. In accordance with which the arbitration tribunal itself has the right to decide on its competence.
Follow, please.
Thank you. Concluding my previous argument, the first and the second sub-criteria for the counterclaim to be considered provided are satisfied indeed. And nextly, respondent states that the counterclaim and principal claim are closely related to each other. Article 2 of the agreement, which you may find on page 22 of the problem 2020, expressly provides that additional contracts will be concluded between the parties to carry out the planned cooperation. Moreover, the above-mentioned article specifies the terms that shall be included into additionally concluded contracts. For example, the types and number of ancillaries, terms of delivery, terms of shipment, and etc. The contract at hand contains such terms, namely all of them. The counterclaim and the claim are connected as arising out of parties' joint commercial activity, which includes procurement, advertisement, and etc. Core document of such activity is the agreement, and the counterclaim arises from it. The contract, also arises from such activity and is not separate from the agreement. Moreover, respondent states that without the agreement, contract would not have been concluded, and vice versa, without the contract, agreement would not have been possible to execute. Thus, the contract was concluded as additional contract to the main agreement. Therefore, it would not have been possible for the principal claim to arise from the contract if the main agreement would not have been concluded. Additionally, the fact that the contract was concluded once again indicates the interest of the respondent to buy and sell the leases, and the claimant's interest to sell the leases. Therefore, the claimant's objections arise out of the supposed violation of its economic interests, the respondent allegedly having transferred the full payment for the leases. The breach of the agreement by the claimant by opening the subsidiary in Palermo was solely caused by the same economic interest of the claimant, specifically to make more profit by selling leases directly to the customers in Italy, as the price markup becomes slower when the goods are sold directly, which is indeed obvious. Therefore, both claim and counterclaim are caused by the same economic interest of the claimants, which make the counterclaim substantively related to the principal claim. In conclusion, I would like to mention the following. Respondent's counterclaim was duly filed as the respondent has the right to make claims arising out of the agreement. Agreement provides jurisdiction of the ICIC to consider respondent's counterclaim, and ICIC rules provide jurisdiction to consider the claim arising out of another document connected to the principal claim. Respondent counterclaim satisfies the criteria established by the ICIC rules for the counterclaim to be considered provided in case if it arises out of another document. And finally, respondent asks the arbitral tribunal to dismiss all the arguments of the claimant concerning the naming of the arbitral institution and interpretation of the arbitration clause in the contract and in the agreement, due to the fact that both of them shall be interpreted in accordance with the intentions of the parties. Thank you for your attention.
Thank you. One remark and one small question. I doubt that we can dismiss arguments. We listen to the arguments and decide on them. And what would you do if we decline to consolidate two claims?
Thank you. Honorable members of the arbitral tribunal. In fact, if the arbitral tribunal decides to dismiss the counterclaim and not to hear it at the current proceedings, it is not the question of what we will do. It's the question of what will happen in the future with the decision itself. Merely, it is in accordance with the New York Convention. Only lawful decisions are to be enforced. And moreover, Russian legislation establishes this principle expressly. And all those issues, and moreover, it is established in Russia that the decisions of the arbitral tribunals are also supervised by the governmental bodies. All those arguments can together will lead to the issue of...
I doubt that this high-level argument with reference to the New York Convention, my humble opinion would say that we just bring a simple claim. Okay, thank you. And now we give the floor to your co-counsel, please.
Thank you.
Good morning, honorable members of Arbitral Tribunal. My name is Veronica Milinchuk, and I'd like to represent the position of CRL Italy Antonio on the merits of the current dispute. In this regard to the structure of the position of the claimant, I'd like to begin with the arguments and put the counterclaim in the end of my speech. The allegations of the claimant are unfounded due to the following reasons. The first one is that the respondent is not responsible for the incomplete delivery. The second one, that the claimant has violated its contractual obligations. The third one, that the respondent has the right to withhold the payment. Respondent is not obliged to pay penalty. And the last one is counterclaim that the lost profit is present and the amount of it is justified. Moving to my first argument, the respondent is not responsible for the incomplete delivery, as according to the Article 3 of the contract on the page 9 of the problem. The delivery should be conducted on the terms DPU Bolzano in terms 2020, and thus, according to the Articles A2 and B3 of DPU in terms the delivery, the place of delivery is specified as the city Bolzano, and the moment when risk have passed to the buyer is the moment of delivery of the goods to the disposal of the buyer at the agreed point, means Bolzano, which is confirmed by the act of acceptance of the good dated the 30th of August 2016. Thus,
Counsel, where does it say in the contract that the DPU delivery of the shipment of machines shall be Bolzano? I don't see that in Article 3 of the contract. Am I missing something?
At the page 9 of the problem, we see the Articles 3 and 4, which is, I'm sorry, the Article 4, it is stipulated that the delivery should be
That's for defective goods, isn't it? What about the original delivery, Article 3?
Article 3, yes. Delivery of goods is to be carried out on the terms DPU in terms 2020. The Article 4, the acceptance of the goods, provides the delivery at the suitable channel, which is also stipulated by the CMR, where it is stipulated the place of delivery where the goods were accepted is DPU, Italy.
Proceed.
The next issue is that claimant has violated his contractual obligations. According to the Article 1st of the contract, page 7 of the problem, claimant shall deliver 5 SMS letters and necessary goods named in a list in the annex to the contract on the pages 11 and 12. Thus, respondent has acted in accordance with its obligations under the Article 38 of CSG, examined the goods with invitation of experts of Chamber of Commerce, and sent a letter concerning founded shortcomings of the goods to the claimant, made an appropriate act. The claimant has violated its contractual obligations and also obligations under the Article 35 of CSG to deliver good in quantity, quality, and description required by the contract. It is necessary to highlight that act was made in the very day of the delivery of the goods, and the letter has been sent in a 1 day, which is considered to be a reasonable period of time. As the parties did not agree the acceptance procedure, the claimant does not refer to any documents that provide the deadline of the submission of the claim concerning the shortcomings, and only freely interprets in its memorandum the concept immediately. We draft the certificate at the same day, and the next day we send it. This period of time is quite fast, as, for example, according to the Russian Federation procedure, an instruction of the procedure of acceptance of the good number P7, acceptance of the products according to the completeness can be made up to 20 days after the delivery, and thus the 1 day is not, it is a reasonable period of time. Even the safety locks haven't been arranged by parties in the contract. It is still the crucial element. As for the Hammer USA company, they stipulate that the safety locks help to provide the safety using of the goods, and the absence of such crucial elements does not allow to not only sell and advertise the locks, but also to use them safely. Also, it is impossible to stipulate in the contract all the parts of the whole leather. Thus, it can be considered to be an argument that absence of the safety locks in contract means the absence of necessity of them. Also, the absence of a Viber support and plus the document prevents respondent from usage and does not allow also to sell and advertise the leathers. Moreover, the respondent states that it has the right to withhold the payment due to the creditor's delay. According to the Article 4 of the contract on the page 9 of the problem, the claimant has an obligation to understaff the goods in case of incompleteness. As the 1st of September, the respondent has sent the letter concerning the shortcomings of the goods with the request to understaff the goods, and hadn't got any response to this letter, it made the respondent to suspend the performance of obligations on the basis of Article 71 of CSG. As it became obvious that the claimant is not going to perform its part of obligations, the respondent has a right to suspend the performance of its obligations. And also, according to the Articles 405 and 406, the debtor is not considered overdue until the obligation can be fulfilled. Thus, it is obvious that the claimant interprets the Article 71 in the wrong way, is if the claimant has not fulfilled its obligations to deliver the goods with the crucial elements. That means that it failed to deliver the goods at all. Thus, the respondent has right not to pay for the goods. which thus there haven't been delivered. On the basis of above mentioned arguments, also the respondent has the right not to pay the penalty. Nevertheless, the amount of penalty is disproportionately high and has to be revised. There are some criteria that are stipulated by court practice and also the provisions of Article 333 of Civil Code of Russian Federation, such as amount of losses caused, the fulfillment of the obligation, property status, and respectable interest of the parties. The respondent in such a situation has an opportunity to get, has no other opportunity to get any advantages besides the protection actually of its right, while the claimant has an opportunity to extract an unreasonable profit from demanding such a high penalty. Moreover, the periodicity of the reduction of the penalty is supported by a few cases in practice that, for example, the case of Arbitral Tribunal of Moscow dated 26th of February 2020, the Open Joint Stock Company State Transport Leasing Company versus GSC Trolza. Court has reduced the penalty from the more than 2 million rubles to the amount of almost 26,000 rubles as the consequence of violation of the obligation by the party, and stated that such penalty was clearly disproportional. Also, based on the facts in the case, the respondent is not obliged to pay a penalty because of the fact that the payment retention has been due to the violation of the contractual obligations by the claimant. And according to the instant matter, the amount of penalty is disproportional and has to be revised. The lost profit in the counterclaim is present and the amount is justified as the presence of a breach is present by the violation of the claimant to refrain from establishing the subsidiary, as the subsidiary is the Italian company, commercial company, which aim to make profit. It is obvious that it is the competitor on the market for the Italo-Tonio, and also the claimant, the owner of the evidence, haven't provided any evidence that the subsidiary has its actions concerning other products than the leathers, but or any commercial activity of the subsidiary. Also, according to the Annex R2, page 29 of the problem, our claim, it mentions that having heard about the opening subsidiary, 3 countries refused to sign contracts with us, which shows the occurrence of consequences for the party and the objective presence of the opportunity for the respondent to receive the income from the leathers. Also, mentioning the argument of the claimant that there are any other products that could be sold by the subsidiary. At the Article 1 of the agreement on page 22 of the problem, the exclusive right applies to the sales of SNS leathers of various brands and products of the exporter. This means that if it is not the leathers, it doesn't mean that it allows to the subsidiary to sell any other products. Also, the respondent has undertaken all necessary measures to and made preparations to receive the income, exactly send a letter to the respondent with a request to understand the incomplete delivery. And also the counterclaim is not dismissible due to the fact that calculation is present by the respondent is usually approximate and probabilistic, and the circumstance itself cannot serve as a basis for denial of the claim. And alternatively, the arbitral tribunal has no right to dismiss the counterclaim, as it's clear from the problem the violation of the respondent rights by the claimant. Thus, in conclusion, the Sierra Tonio claims that, based on the mentioned facts, the respondent lawfully withheld the payment of the goods due to the creditor's delay, and has a legal right to recover the damages incurred by Italy-Tonio CRL due to the breach of the obligations by Stankamash under the agreement. Therefore, respondents ask the arbitral tribunal for the following orders: to order Stankamash to pay in favor of Italy-Tonio CRL €1 million as damages incurred by Italy-Tonio CRL due to the breach of obligations by Stankamash under the agreement, and also registration and arbitration fees, and also to dismiss the claim of Stankamash in full.
I'm sorry. I'll ask two small factual questions. Page 19. Para 10, last sentence. Is it correct that representatives of the Chamber of Commerce and Industry of the Russian Federation will confirm to the act of acceptance of goods? The act, which I've seen in the documents, the act was signed by Italian personnel.
Yes, but also according to the Cambridge dictionary, the act is a document which made by certificate. It is a document which made by the competent authority on the certain issue, and the experts of Chamber of Commerce which have been invited to making this act are certainly the competent authorities, and thus we can infer that the act is appropriate document to state the shortcomings and damages of the goods.
Thank you. You refer next para 11. You refer to Article 71 of the Vienna Convention. I recall that it concerns so-called anticipatory breach. Anticipatory breach, the breach which might happen in the future. Though, is it not correct that in this case, well, the damage was done? It's real damage, not anticipated. How you comment my question?
If I understood you right, it is whether there is the breach of the obligations, or I misunderstood you.
My question is that is the damage you suffered real damage, or the damage which will be evaded in the future?
It is at the same time the real damage and the lost profit. According to the real damage, the goods have been also paid for 10%, and also the party, the respondent, cannot advertise or sell them. And also 3 companies that refuse to sign contracts represent the also, if you let me, I'll show the calculation of the losses. It is.
Thank you. And last but not least, yes or no question, like it's been said in America, yes or no question. Did you ask for substitutions of the deficient goods?
Could you repeat, please?
Did you ask from the claimant for the substitution of those defective goods? Or no?
Of course, we have sent the letter not only concerning the with the act of shortcomings, but also
Yes or no? Yes or no question. Well,
dated 30th of August 2016 and the 1st of September.
okay.
Yeah, I have a question. Forgive me for returning regularly to real life facts and situation. Again, you've admirably, counsel, you've admirably argued your case, cited supporting law and other materials in support. But I have trouble on the basic premise that the claimant's mere opening of a subsidiary in Italy amounted to a breach of the distribution agreement and to your arguments that it caused you grave damages. I don't see any support in the distribution agreement that prohibits for the proposition that claimant was prohibited from opening a subsidiary. Indeed, as we see in Russia, and I think all over the world, a producer, a manufacturer may have distributors in another country. They may have exclusive or non-exclusive distributors, and yet they open a subsidiary or a representative office for representational purposes. What's the problem? Where's your evidence that this caused you damage other than your allegations? I mean, you have all sorts of allegations of damage of all sorts, and you could add moral damages, emotional damages. My God, they opened a subsidiary. What's the problem here?
It means that according to the contract distribution agreement, exactly, it is provides for the Teletona the exclusive right to sell, advertise, and at the same time, opening the subsidiary, 3 clients have refused to conclude contracts with the Teletonio for this reason. It is actually shows the effect of the subsidiary which was made on the our clients. It breaks this exclusive right to sell and advertise. The core aim of the subsidiary is to advertise and to sell the products. And if the agreement provides us the exclusive right, it means that opening such a company is the breach of this right.
Okay, Mr. Kulov has also his questions. Please.
Yes. My question also relates to the distribution agreement. I understand that the claimant's argument is that the distribution agreement only relates to the CNC letters. At the same time, there are also non-CNC letters, other letters without CNC, which were authorized, registered by the claimant in your jurisdiction. And their argument is that nothing prevents them, at least, from marketing these other leathers without CNC in your country. I couldn't quite get your response to that.
At the Article 1 of the agreement, it is provided that this exclusive right applies to the sale SMS letters of various brands and products of the explorer.
No, sorry, it says CNC letters of various brands. So various brands of CNC letters. I don't understand how you can read it differently.
The products in the brackets. It also can be interpreted as the other products, but the SMS letters.
Okay, thank you.
Okay, I will consult without confidentiality with my colleagues. Let's move to the next stage, perhaps. Okay, so as we agreed upon before, well, parties can interrogate each other several questions, important questions on each side. Claimant, do you have questions to the opponents?
Yes, Mr. Chairman. And we would like to start with the questions on the jurisdictional part of the dispute. Namely, we would like the opposing counsel to clarify. They referred numerous times to the intent of the parties to submit the dispute to the ICAC. We would kindly ask the opposing counsel to provide any evidence in the record, any piece of evidence proving that the parties had such an intent at the moment of the conclusion of the distribution agreement, which is in question in this dispute.
Respondents, please.
Thank you, honorable members of the arbitral tribunal. Thank you, representatives of the claimant. I would like to mention that the indications of the intentions of the parties comes from the above mentioned position by me. Well, due to the fact that the correct name of the arbitral institution was mentioned, in the documents between the parties, and moreover, the disputes were referred there. And moreover, the question is whether there is any other way to interpret the agreement of the parties to arbitrate the disputes. So in the interpretation of the respondent, parties agreed to refer all the disputes which were risen in the current proceedings to the ICAC. And if there is any other way to interpret the agreement between the parties, I would like to kindly ask the claimant to name such an interpretation, due to the fact that respondent sees no other. And moreover, the indications of there are a lot of indications in the documents between the parties that indicate the intent to refer all disputes to the ICAC. For example, the name of the institution was once again referred by the parties. And due to this fact, it would be unreasonable to refer the disputes which are so closely related to any other arbitral institution. And indeed, parties understood that fact.
Perhaps it's enough. We don't have much time, and perhaps there might be other questions. Please.
Yes, I would like to finish here. That's my answer.
Do you have questions on your part?
Yes, indeed. I have reasoned this question during my answer. And the question is whether there are any other way to interpret the intent, the intentions of the parties to which you have, to which the claimant have referred in its memorandum.
Okay, claimant, briefly, please.
Oh, of course, Mr. Chairman. There could easily be other intention of the parties at the moment of the conclusion of the distribution agreement, especially giving attention to the fact that the distribution agreement was concluded previously to the contract. For example, there is at least 2 arbitral institutions in Moscow who would be authorized to consider international disputes. Moreover, the parties could have meant the Russian state arbitrage courts, and due to the confusement in the name of these courts in Russian procedural law, the parties could have referred to them as to the arbitration court, as it is stated in Article 9 of the distribution agreement. Therefore, we submit that there is no clear evidence of the intent of the parties at the moment of the conclusion of the arbitration clause.
Thank you. Perhaps a couple additional questions as concerns the merits of the case.
Thank you, Mr. Presiding Arbitrator. I would like the representative of the respondent to show us any evidence of the losses which the respondent had due to the alleged activity of the SRL Pakistan, except for the words which were said in the claim signed by Giuseppe Zanotti. Thank you.
Okay, respondents?
Yes, of course. The total amount of losses is calculated by the respondent, and it is 20 letters for the refused contracts, 86,500 euro each, plus advertising and other promotion to be short services at cost 150,000 euro. Also, it is a total cost of 1,880,000 euro, which is almost twice more than is requested by the respondent as 1 million euro in its counterclaim, and also the 200,000 euro as reputation of liable firm, which have lost the respondent. To ask my question, it is...
Okay, yes, your question, please.
Yes, actually, is there any proof of the claimant, as he is owner of the evidence of the actual activity of the subsidiary, has to prove that this subsidiary has another aim of its existence than to gain a profit and to be a competitor to the Italy on the market?
In this regard, we would like to state that if the respondent has some kind of an impediment which prevents them from fulfilling their obligations under the contract, the burden of proof for existence of such an impediment lies with the aggrieved party, which is the respondent and not the claimant. So the respondent here is the one who must present the evidence of the breach of the contract from the side of OO Stan Kamash and the subsidiary SRL Panzistan.
Okay, my proposal is to give the rest time for arbitrators. Perhaps you might be also interested in their additional questions. And we start from Jonathan, you, then Timur, you, and then I will finalize.
So I can ask one more.
Yeah.
Okay, I would like to follow up on this issue of the distribution agreement and the subsidiary. A question for the respondent co-counsel. Do you know whether your client ever raised with the seller, claimant, before this dispute arose as to the purpose of the subsidiary, any problem with it, any bad feedback you were getting, your client was getting from your customers, from its customers? Or did this complaint about the subsidiary arise for your client and therefore for you just when this dispute arose? It's a little bit odd for me.
At our claim to the claimant, in Annex R2 on the page 29 of the problem, it mentions that 3 companies have refused to conclude a contract with Italy as far as they know about the existence of this subsidiary. And it is the evidence for us to that this subsidiary cost us the profit and the clients. And also the tribunal has decided the case on the basis of available information, and the claimant hasn't proved any evidence of another activity of the subsidiary than gaining the profit and taking our funds.
I have a question for the respondent. So you delay payment for the equipment, and you say that you delay this because the claimant didn't perform its obligations properly. Do you accept first that the value of the obligation, the price of the missing equipment is not proportionate to the amount that you do not pay, that you withhold the payment? That's the first question.
Yes. Concerning this matter, it is not more about the price of the safety locks themselves. As for
No. My first question was about the price. So do you agree that the value of this equipment is disproportionate to the value which you withhold payment?
We're not concerning the the price of equipment, more about the matter of these details.
No, my question is with respect to the price of the equipment. Can you please answer my question?
Yes.
So was it yes, right?
Mm.
Sorry, I couldn't hear.
Yes.
Okay, thank you. And then my second question is, how do you think the situation shall continue? So for how long do you plan to withhold the payment? So what do you think will be the necessary consequences of this situation? Or do you anticipate that this situation will continue for a kind of indefinite time?
As we mentioned, it is in our claim to the respondent, as soon as the claimant understands the necessary safety locks, fiber sport, and documentation to make us fulfill our obligations according to the contract. to advertise.
My question is, for how long are you going to withhold payment?
As long as it is the absence of necessary details and documents,
Okay.
far as claimant withhold the goods.
Okay. Okay, thank you.
Okay, thank you. I'm just negotiating about the timing. Okay, I have also several questions, but my colleague, my distinguished colleague, Mr. Hines, also asked or just repeated the previous request that we should like to have some time to make to express our feelings and considerations about what was happened. Okay, let me, as some wise arbitrators say, ask questions addressed to both parties. I presume I will expect short answers. Who unloaded the transport? Who unloaded the goods in Bolzano or somewhere else?
The seller?
Claimants.
Claimant.
Yes, we confirm that, Mr. Chairman.
Yeah. Who unloaded?
The representative of our client unloaded the goods to the representative of the respondent.
And who was responsible for the unloading goods under the DPU term?
Under the DPU, our client was responsible for the unloadment because the goods are transferred after they are completely unloaded from the vehicle.
Okay. Respondents? Same question.
Yes, agree that the response for the acceptance of the goods was unloading the goods was on this claimant.
Okay, claimants and respondents, same question. What is the importance of reference to the fundamental breach of the contract as provided in the Vienna Convention? Well, if we decided there was or was not a fundamental breach, what are the consequences under the convention related to this category of the fundamental breach? Claimants.
The essence of this argument in the present disputes, Mr. Chairman, is that if the breach was not fundamental, which it was not, then the respondent does not have a right to suspend the contract and to withhold the whole price of the goods, but simply to compensate the lack of their details in dispute.
Respondent?
I need to highlight that a respondent does not refer to the fundamental breach, but to the non-delivery of the goods at all due to the absence of the important details of the goods, and refers to not only to the Article 71, but also the Articles 405 and 406 of Civil Code of Russian Federation.
Well, I will share with you my vision on the Article 25. The fundamental breach allows the creditor to terminate the contract with the due notice to the other party. Okay, as agreed, we now come to the final stage. Well, what is your vision, Mr. Hines, about well, the presentations, and what you would perhaps advise to the representatives of the parties to take into consideration for the future?
Yes, First, I would like to congratulate both sides. I thought your presentations were all really, really good. And as an American whose people do not speak foreign languages very well, let me add that your ability to do all of this in a foreign language for you is quite admirable. I would advise, I had some specific comments about say some relatively stronger and weaker points in certain answers from one side or the other, from one council or the other, but I won't go into that. I'll make one point, and I think this applied mostly to the council on the respondent side, but also on the claimant side. It's very nice to be able to cite all of the laws and other supporting authorities in support of your case as a technical, clinical matter, as I would say. But I would advise you to also focus, anticipate on what I've called a few times in my questions, the real life situation, because we're all human beings and we all want to focus beyond the technical, clinical laws to what's really going on, what really grabs us as human beings. Even arbitrators are human beings. And so it would, I think, be to your benefit to anticipate, even though the record is not complete and your case is not perfect as given to you, do your best in real life or in this exercise. You take the case as it's given to you, but do your best to anticipate real life consequences, aspects of what's really going on, and be prepared to answer as best you can in a way that will be as convincing as possible, again, on the real life basis, not just on the technical, clinical laws.
Mr. Itkulov, please have your time.
Thank you, Mr. President. I have the following comments. Well, first of all, I fully agree with my co-arbitrator, Jonathan, that the performance was excellent on both sides. And I also would like to congratulate both teams on that. My first comment is that I understand that in accordance with the rules of this moot court, it was possible for the parties to prepare PowerPoint presentations for the hearing. So you may consider that in some situations this may be helpful for the tribunal to better understand your position. And well, maybe if one of the parties had PowerPoint presentations in this case, then this would have made that party's position more convincing. Second point is that please, when you make your argument, please do not forget about important facts that relate to your case, which maybe are set out in some documents, but which you do not voice, which you do not talk about during the hearing. And I have identified several issues here when one of the parties was making a presentation and then referring to certain facts, but then it was not clear to me whether, these facts were in the evidence or not. So if one of the facts is important, then what you should do is you need to refer to a specific document in the file so that the tribunal can take a look and be persuaded that what you're talking about is indeed the position in the case. And then I had a third argument. Yes, this relates to the team, more kind of to the team of the respondents. Sometimes it was quite difficult to follow because counsel was speaking quite quickly, and sometimes maybe that the issue with the connection, but sometimes for me it was quite difficult to follow what was exactly the position of the respondent on certain points. So if you could, for the future, if you could be more kind of concise, if you could talk slowly, make a presentation in such a way that you are sure that people to whom you address your presentation are actually able to understand it clearly, that would be your advantage. So thank you. But overall, I think that was a very good performance on both sides.
Thanks a lot, Timur. I'm glad to say that I am fully agreeable with the what you expressed, and this is a real expression of real arbitration. And being captain of this vessel, so to speak, in Maritime Arbitration Commission, we have many sayings about this vessel, marine enterprises. So what I wish to say lastly, to recall saying which distinguished Professor Rosenberg used many times. Also, in numerous conferences held in this hall, he was very energetic in proposing the idea that it's not necessary to make parallel references to the Vienna Convention and other sources. And he would say, and I have the moral right to say this, of course, all of us, we read the books of distinguished Professor Rosenberg. I made several commentaries about his works, and sometimes I expressed a dissenting opinion, but here I am fully in agreement that if you refer to the Vienna Convention can be supplemented by additional sources with regard to conditions provided by Article 7. So if you don't find a clear answer in the Vienna Convention, and you cannot, squeeze this result from the relying on the general principles on which the Vienna Convention is built, only in this situation you can go further to find subordinate rules in the national law. And of course, I'm not blaming you. The case was not prepared by yourselves. And this is a usual, perhaps, approach in many cases with participation of Russian parties. But, the ideal way is such as proposed and promoted by Professor Rosenberg. And I am concluding that I was not satisfied about the response to the questions of interest and penalty. Shortly I'll explain that these are different categories. Interest under the Vienna Convention, this is one thing. And the Vienna Convention does not say anything about the penalty, which is totally regulated by the national law. So we came to the last point, and since we have 2 minutes, several few words from our representatives. Claimant, please.
Thank you, Mr. Chairman, the distinguished members of this tribunal. We would like to express our gratitude to both the organizers and all the people who participated in these proceedings and all the proceedings in course of this moot court. And we hope that all the teams participating in the competition have enjoyed their participation as much as we have.
Thank you. Respondents, please.
Thank you, honorable members of the Arbitral Tribunal. I think it is possible for both me and my colleague to say a few words. I would like to make some, I don't know, points about whom I want to thank. I would like to thank everybody who was involved in the organizing of such an excellent event. I would like to thank you, honorable members of the Arbitral Tribunal. I would like to thank claimant for the excellent, I don't know, may I call it a battle in a sort of. And I would like to thank our coach, Terehov Kamal, for excellent job that for the help of his during our preparations for the current event. Thank you.
Yes, and I want to support and join my co-counsel and to express not only the gratefulness for all the members of the competition or to our coach, but also to say that it is a wonderful experience, not only as for students to know more about law and procedure, but also as a beginning lawyer, as a member of the during court procedure, and it is a really interesting and wonderful experience. Thank you very much for that.
Thank you. Thanks all the participants to this wonderful event. And afterwards, we are going, Jonathan, 15 seconds, as you promised.
I want to just support an important point made by my colleague, Mr. Adkulov. You may wonder when he made his comment, well, I have to make all my arguments, but I have a time limit. Just keep in mind, again, you will have submitted complete papers which make all of your arguments. It is indeed important, as my distinguished colleague said, that you try to speak slowly, make your main points, and make them stick. And a lot of the detail you can leave to your papers or questions that the arbitrators may ask.
Very true. And now, as prescribed by the rules of the International Commercial Disputes of ICC, we, unlike in previous times, we will not declare the award or resolutive part of the award as it was in previous, but we now just depart to start to formulate our award, which will be announced in due time today. Thank you.
Thank you.
Thank you.
Thank you for your attention.